Thank you for joining us. We're going to talk today about how to avoid having to sell the ranch, good, the bad, the ugly, about how the Duttons could have avoided the need to sell their ranch to pay federal state taxes. Many, but not all of you, may have had a chance to watch the episode on streaming TV of Yellowstone. Little did I know when I started watching it that in the end, it was going to be all about state planning and estate tax issues. Yellowstone, as you can see, is an American neo-Western drama that reviews many issues associated with ranching in the United States. Of course, it is quite dramatized, and I personally found it to be very interesting. If you haven't watched it, I hope you take a chance to watch it. These are the characters in Yellowstone. John Dutton is the father in charge of the family. Casey is his sort of not black sheep son, but more aggressive son. Beth Dutton is his ultra aggressive pit bull daughter. The thing that animates Beth the most is if anybody tries to do anything to her family, and in particular to her father. Monica is Casey's wife. She's Native American. That plays into the conversation. Jamie is an adopted son that has issues with the whole family and ultimately leads to his demise. Rip is Beth Dutton's longtime boyfriend who ultimately appears to become a spouse, but undetermined until the next episodes. So again, it's a hypothetical scenario about what could have happened and what the Duttons could have done to avoid having to sell their ranch. So we're going to work on issues associated with avoiding or minimizing intergenerational conflict, federal estate taxes, and control issues. John Dutton, like many of our clients, always wants to have control. In addition to that, he is very possessive of his land. As it says on the slide, all I have is this land, direct quote, and I'm not selling a damn inch of it. So he explains that the fight is the family fight, and to give up is to give up the family. What are the risks? The risks that are associated with the Dutton Ranch are several. First, there's always going to be development. It's out in the Yellowstone area. There are many developers and corporations that would like to buy the property and develop it into resort homes, ski lodge, or any number of those types of things. There's always politics, taxes, federal state taxes, state and local taxes. Are they going to bankrupt a rancher who makes their entire living on raising cattle? Prices go up and down. Taxes seem to be steady. It's a significant risk for liquidity. There's continuing native land claims. We mentioned that Casey's wife, Monica, is a Native American, and as part of that, her tribe actually has claims to the land. There is violence associated with the family, with betrayal, and sometimes also getting crosswise on politics and betraying the family with development and or corporations that want to buy the land. Lastly, there is financial fragility. As I mentioned earlier, it's the lack of liquidity, the fact that they are land rich and cash poor and rely for their revenue entirely on cattle ranching. So one of the questions and one of the issues in federal estate tax planning is how to make an asset worth less than it would otherwise be accounted for federal estate tax purposes without actually diminishing the value that the family feels for the land. In this hypothetical, the ranch is worth $200 million. A flat 40% federal estate tax would be $80 million in tax. One of the important tools that can be utilized in order to reduce the value of raw land, open land, undeveloped land, is a conservation easement. A conservation easement is a voluntary agreement, one that is typically proposed by the landowners, that doesn't change the ownership of the land, but restricts the potential development of the land, and it can preserve the current status. The Duttons have cattle ranching on the land, so it preserves their current use and operation of the cattle ranching, their scenic views, all of the things that they value for the land. Importantly, the conservation easement runs with the land. This means that the restrictions apply to all future owners in perpetuity. Thus, the ranch will always remain a ranch. Question sometimes arises, who will be eligible to enforce the conservation easement? In this case, we picked as one example the Rocky Mountain Elk Foundation. They are a conservation organization with whom the Duttons could potentially work. We have the easement. We talk about that. The property value is the assessed value of the land for its agricultural open space. And because the easement runs with the land and the development of the land would be precluded, it substantially reduces the value of the land. Thinking about a willing buyer, willing seller. The only thing that you can do in the land, the only activity you can conduct is ranching or farming of some sort, then the value of the land is the income that you can earn from those activities. If you cannot subdivide it, develop it, or do other things to it, the value of the land is going to be substantially reduced. So that reduces the property tax and the value for federal state tax purposes. However, the family retains the management control, the ranching, and they have some limited building rights. Those building rights would be the rights to build additional structures necessary for the ranching operations. Public access is optional. The Rocky Mountain Elk Foundation, we found out, actually does offer private use only easements for preservation of land. The Rocky Mountain Elk Foundation wants to preserve Rocky Mountain elk. They prefer to have it open to public. They do not require it because preservation of the elk and the environment is their primary goal and their charitable function. Perpetuity means that the assessment, its limitations, runs forever. That means that all future owners, descendants, are legally bound to the conservation terms. Somebody, however, has to enforce the conservation easement. That is the Rocky Mountain Elk Foundation. If the Rocky Mountain Elk Foundation goes out of existence, then its successor, if any, would have to enforce it. And if it has no successor, then the Montana Attorney General, as a protector for charities, would enforce the easement. Now we're thinking about this. We talked about this. Beth came to us and asked about it, and we convinced her this is a good idea. She has to convince John Dutton it's a good idea. So she's talking with her father and talks about the Rocky Mountain Elk Foundation. John initially does not like the idea because he doesn't want anybody hunting on his property. However, as she emphasizes, we give it to them, no developer, no governor, no market equities, which was one of the corporate threats, or lawyer could ever touch it. The ranch becomes what it was always meant to be, untouchable. What does that mean? And this is where the rubber meets the pavement for tax purposes. So assuming a death in 2026, if we have no easement, we have a $200 million taxable estate. With the $30 million exemption, we have $69,386,000 in tax. With the easement, and the easement, don't forget, reduces and eliminates all uses on the land except for agricultural. Could a farmer actually pay $40 million to make money? It's maybe a little questionable, but in theory, what happens is we get an 80% discount on the value of the property, which means the value goes down by $160 million, as we'll show later. We get an additional exclusion under 2031C of $500,000. So we reduce our tax liability to $5,168,000. And footnotes 1 and 2 show you how we computed that. So by granting the easement, we save $64,200,000 in tax. Also, there's a special exemption for conservation easements that are granted by or for agricultural purposes. It's a $160 million income tax deduction considered to be a charitable income tax deduction. Likely, John Dutton will never have to pay the federal income tax for the remainder of his life. Now, if you're a tax person, you might be saying, well, yes, Tom, but there are limitations. That is true. However, there's a special exception for a qualified farmer or rancher. That special exemption, as exhibited on this slide, allows John Dutton to deduct up to 100% of his adjusted gross income on the land. He has to continue with the agricultural use, of course. Unfortunately, any unused portion of the limits would only go forward for 15 years. However, it may be extended in additional legislation. Again, to qualify, 50% or more of the gross income must be from farming or ranching. Key takeaways: standard conservation easement, 30% AGI limitation, 5-year carry forward. Qualified farmer or rancher, preferred donator, 100% AGI limitation, 15-year carry forward. Easement may be disregarded. Entity wholly owned by John. So the easement may be in an LLC that's wholly owned by John, and he still gets the deduction for it. And that's important because as we go forward, we're going to talk about control. So what we've accomplished so far, we've got the land preservation and family control because John has been able to reduce the value by using the qualified easement, and he retains the operational use in a single member LLC, which is disregarded, and protects the land from development forever. But that's during his lifetime. What do we do next? Step 2. The issues we want to accomplish here are long-term control, asset protection, and management. The Duttons will create 2 LLCs to hold the land and the operating entity. Yellowstone Ranch LLC will own the land, and the operating assets, the cattle, etc., will be owned by Yellowstone Cattle Company LLC, which we'll abbreviate as the cattle company. By separating the real property, dirt, from the operations, the cattle, we're able to partition off the risk of the operating cattle company, so that when the horse throws somebody and kills them, or the cow wanders onto a public road and somebody's injured because they run into it, at risk will be the operating assets and not the dirt or the actual ranch property. Also, the LLC structure for both entities provides centralized management through the generations. We're going to talk more about that in coming slides. It also importantly allows for fractional interest to be created and gifted for additional flexibility in discounts. Because remember, we still had a $3 million tax due after John dies, and they aren't real liquid, so we got to deal with that. So how does it happen? John creates the LLCs. John contributes the $40 million post-easement Yellowstone land, the dirt, to an LLC. He also then contributes the operating assets to Yellowstone Cattle Company LLC. Both entities have 4% Class A voting shares and 96% Class B non-voting shares. So to the point we made just a minute or two ago, is we're going to separate the control from the vast wealth of the entities, and most of the wealth is going to be in the non-voting interests, with the control being in the voting shares. Both LLC agreements provide for the voting and non-voting, as I just mentioned. This just reiterates what I've already said. The important part about this slide is that because we have fractionalized the interest in both the operating assets and in the land assets, we are able to claim a discount. We would go to an appraiser and say, what is the value of an interest in the voting shares of the LLC? What are the values in the non-voting shares? An average discount is probably 35% or more. So that brings our average value down substantially for lack of control and lack of marketability. It brings the overall value down to $26 million. The key provisions to consider, as I've mentioned, is that the manager-managed LLC centralizes management in one or more managers. The Class A shares control who the managers are. Thus, we can separate control from economic benefit. Economic benefit is mostly going to inure to the benefit of the Class B, 96% non-voting shares. Class A gets economic benefit, but only to the extent of 4%. Therefore, we have been able to, again, bifurcate control versus economic benefit. We're going to include transfer restrictions, in particularly on the voting interests. A discussion will occur among the family members about who they're going to allow to be members or managers of the entity. There'll be buy-sell provisions. There could be put and call provisions. An example would be 15-year buyout on a put or a call, taking into account conservation easements. That would be a 15-year buyout at the $40 million value, not at the $200 million value. And that would be in the event that the family decides that it makes sense to allow somebody to put their interest. A put means a family member says, I want out, buy my shares. It could be mandatory or it could be optional. And the call provision would be somebody is not cooperative and the family decides we need to buy out. Let's say Jamie because he's off the reservation, no pun intended, and we need to make sure that he's eliminated because he's a disruptive member of the family. So now we're sitting in a meeting with John, and John says, Tom, this all sounds good, especially when we're drinking bourbon, but I'm not made of money. This ranch makes a lot of money, but it costs a lot of money to operate. Not much money sticks around. So what have we accomplished? John has a lifetime exemption of $15 million. His wife has a carryover exemption, portability exemption when she died of $11.58 million. So we have a total exclusion of $26.58 million. We've gifted the non-voting units in the ranch, which was $26 million post-discount value. Result is we've transferred all that value, federal estate gift tax free. It will all appreciate outside the state, subject to the conservation easement. Here's what it looks like in a flow chart. So again, we have John, he funds the real estate LLC, he funds the operating assets in the LLC. He retains the real estate LLC for a bit. He transfers the cattle ranching LLC, and he gives each Beth, Casey, and Jamie 32% non-voting. The estate tax exposure for the ranch is zero. It's fully excluded. Estimated tax savings is $16 million, 40% of $40 million. Property tax base is reduced due to easements, so we're going to have lower property taxes. John retains full control and management through the voting units. Montana has an old styles perpetuities period, all lives in being, plus 21 years, which is basically 100 years. However, we can always find another way to deal with that. So, perpetuity, John says, Tom, this ranch has already been owned by our family for 143 years since 1883. There's a whole other series called 1883. I recommend you watch it. 100-year perpetuity period is just not long enough. I am thinking more in terms of the Roman Empire. Well, there's good news. Because we have South Dakota right next door, and South Dakota has a much longer perpetuities period. With appropriate planning, we can take the trust and borrow South Dakota's perpetuities period. John Dutton, as a resident of Montana, because we have fractionalized the assets and converted them into LLC interests, can form the trust to be governed by South Dakota law and administered by a South Dakota trustee. The trust is gifted membership interest in the Dutton Ranch. The LLC remains a Montana entity. The trust becomes a member of the LLC. All ownership records reflect South Dakota Trust as a member. The trust administration, which will be de minimis, distributions, recording, record keeping, tax filings are handled by the South Dakota trustee, keeping the situs intact. However, all the heavy lifting is done by the Montana LLCs running the ranch and dealing with the day-to-day operations of the cattle company. The result, the LLC remains subject to Montana entity law, but the trust itself is a South Dakota trust, benefiting from the much longer perpetuities period, longer than the Roman Empire. We get asset protection, no South Dakota state tax or income tax, and we retain all of the income. Question to John, does Tom get a bonus? I think not for most clients. So, federal tax reporting considerations. The trust is going to be structured as a grantor trust, which means all of the income will flow through to John Dutton's income tax return. Why is this important? It's important because John Dutton has a huge charitable deduction carried forward for the next 15 years, which means that he will not have to pay tax on any income earned by the trust until it exceeds $160 million charitable deduction that we had illustrated that he got earlier in this presentation. The trust will have its own EIN. It will be irrevocable. The LLC's income will pass through the trust, as I already mentioned, to John Dutton as the grantor, and the trust will file a Form 1041 grantor trust reporting statement. There is no state level tax in South Dakota. The gifts of the LLC interest will require an appraisal and filing a Form 709 for gift tax purposes in the year following the year of the gift. So if this was done in 2026, the gift tax return would be due by April 15th of 2027. It can be extended through October 15th of 2027. South Dakota trustees, administrative only, preserves our situs. They will work with the family on investment committees for Montana for investment and distribution guidance. Both LLCs can pay large market rate salaries for compensation to the managers if desired. Key provisions. The pro-rata distributions will be provided for in the LLC operating agreement for both voting and non-voting interests. Question arises, when John Dutton passes, what is the income tax going to be? His charitable deduction carry forward will evaporate because it happens upon his decease. However, we want to preserve the general status of the trust for being income tax neutral. Question is, how do we do that? The LLCs owned by the trust could elect at that time to become subchapter S entities. So they become essentially S corporations, retaining their LLC status but electing S corporation status. If the trust then make what's called a qualified subchapter S trust election or the QSST election, then for federal income tax purposes only, the trust is disregarded and all the income will flow through to the trust beneficiaries. A good operating agreement is going to have dispute resolution and take into account deadlocks. This means that Rip hopefully doesn't have to take him to the train station, which means not having to kill them. Management provisions, supermajority vote will be provided for major operations of the trust, potentially even of the LLC, dissolution of the entity, or material business matters. We always recommend a very important addendum to the agreement, a letter of intention from the founding generation. The letter of intention from the founding generation would be John Dutton's expression of his overall governance and goals and objectives, with the notion that he would write it to the family, trying to help the family fill in the blank that would sound like this. If Dad, John Dutton, were here, he would blank. So we would encourage the senior generation to write general guidelines and provisions, some of that being never sell the land. That would be his goal. So the purpose of the voting and non-voting family governance, maintain family control of Yellowstone Ranch while defining succession for the family lines. So typically there'll be family lines that will control. Structure and overview. All voting LLC units transferred into Yellowstone Voting Trust Agreement. 3 initial family lines. There'll be 3 initial family lines. Beth, Jamie, and Casey. Each line would appoint a voting trustee. What does the voting trustee do? They would elect the LLC managers. Beth's board seat carries 2 votes. Why? Because she's Beth. Upon the death of Beth and Jamie, no descendants. Casey's son Tate and other descendants will become the remaining family lines. If Tate was the only family line at that time, then he would be the sole voting trustee and hopefully can reestablish family lines with his descendants. So what have we accomplished? We got voting trust, succession, and control flow. We got the family lines, in this case, Beth as trustee, who would vote for the LLC members, is going to get 2 votes. Jamie and Casey each get 1. So at a minimum, Beth gets veto power. The LLC board composition will elect by the voting trust, long-term outcomes, unified control under Tate's line because he may be the only family member surviving at that time. Perpetual funding via Yellowstone Ranch Operations Trust. The Yellowstone Ranch Operations Trust is going to be funded with a life insurance policy we're going to go over momentarily. We have the conservation easement, the LLC, governing layers to ensure Dutton legacy and stability. Life insurance integration with perpetual ranch liquidity. One of the concerns always is that the ranches lack liquidity. They have their ranch operations, which can be affected by weather, by disease, etc. So we're going to try to ensure that the Yellowstone ranch operations maintain liquidity in perpetuity. Key features are going to be, we're going to have life insurance policies owned by Yellowstone Ranch Operations Trust, as I just mentioned earlier. The proceeds provide a tax-free liquidity to fund operations, property taxes, and conservation upkeep. It ensures long-term financial stability for the farm. They would use a permanent policy whole life that provides tax-free proceeds upon the insured's death. Variable and universal life can also be used. We would check with your local insurance expert to understand the benefits and detriments of both. Death benefit can be used to pay estate taxes when due, but as we note right now, if Knox Law is doing the planning, there will be very little estate tax due because of our wonderful planning. John, in this process, would create a trust with Beth as trustee. Beth, as trustee, will purchase a survivorship policy on John and his deceased wife, Evelyn. This would presume this was occurring prior to 2019 and her death. John gives money to the trust each year that Beth then uses to pay the policy premiums. Upon the last to die or second to die of John and Evelyn, the trust receives a death benefit tax-free. The Dutton family portfolio may want to be even bigger, though, because it's expensive to buy policies on the Duttons because John and Evelyn were older. Maybe we get a $5 million policy on them. This year, so is John, because we were evidencing this after Evelyn's decease. So his life would be the one controlling it. So for the John Dutton $5 million policy, it goes to the Yellowstone Ranch operations, providing liquidity for conservation funding. Beth Dutton, $2 million. Her $2 million could be dedicated to transition, liquidity, management, and support. Jamie Dutton, $2 million, governance, legal continuity funding. Casey, livestock and operations funding. Nothing is set in stone, but we have $11 million of funding that would occur outside of ranching operations to assist with liquidity needs and the lean times that all ranchers experience. So what does it look like in a flow chart scenario? So we have John Dutton putting everything together. He forms the Yellowstone Ranch LLC that owns the dirt. He has 4% voting and non-voting. Same thing for the cattle company. It has all the operating assets, cows, trucks, etc. All of Beth, Casey, and Jamie each receive an equal 1/3 interest in the non-voting interest for the cattle company. The 4% remaining interest in the dirt or the Yellowstone Ranch Company will most likely be passed upon John's death. That's the voting interest. The non-voting interest would already have passed. So what have we accomplished with this slide? So John Dutton has created two separate LLCs, Yellowstone Ranch LLC and Yellowstone Cattle Company LLC. The Cattle Company LLC, again, is divided between 4% Class A voting and 96% non-voting. Likewise, the ranch operation is subdivided in the same voting and non-voting interests. For ease of this slide, what we're going to do is there's going to be a gift or part gift and part sale of the non-voting interest in both the cattle company and the ranch company to the trust for the benefit of Beth, Casey, and Jamie. The 4% voting interest in both entities will be transferred to a separate Yellowstone voting trust agreement. So when you look at this slide, the Yellowstone 4% voting trust agreement is going to own 100% of the voting interest in both Yellowstone Ranch LLC and Yellowstone Cattle Company LLC. So whoever controls that entity will control all of the operations. However, the economic interest that we explained earlier will be owned in equal shares, as evidenced by both Beth, Casey, and Jamie owning 32% of each of the voting interest, of the non-voting interest, the non-voting interest in each entity. So again, I said this already a bit. What have we accomplished? We created a self-sustaining multi-generational structure, ensuring family control, tax efficiency, and conservation. The core elements, Yellowstone Ranch LLC, we have centralized management of all the assets. We have the conservation easements, which means that we have restricted the development of land forever. We have the voting trust, which is going to provide for the control over both the land and the business aspects. We have the Yellowstone Ranch Operating Trust, which can be funded with life insurance that will provide liquidity for multiple generations through life insurance policies on both John Dutton and all three of his children. We have separate dynasty trusts for each of John's children and their family lines that will hold the economic interest and the non-voting interest for the long-term wealth preservation for the families. So we have formalized the entities and trust structures. We have all agreements in place. We maintain the Montana Agricultural Classification and easement compliance annually. We continue the premium funding for the various life insurance policies owned by the trust. We hold annual family council and LLC board meetings for governance transparency. Government transparency is very important. We may have to add a professional ranch manager or a co-trustee for the future generations. Tate, think of a family private enterprise model. Tate may want to govern the ranch. He may want to be a dentist and have somebody else run the ranch, but still be involved in the ranch. We're going to allocate GST exemption to the Dynasty Trust to ensure long-term federal estate tax-free growth. And we're going to consider a Dutton Family Conservation Foundation that may align with the Rocky Mountain Foundation mission. Now we've got the finalization of these activities. And I sort of described this in the slide we looked at earlier. At the end, we have Beth, Casey, Jamie owning 32% non-voting interest. That's the economic wealth, but it is of both entities, the cattle entity and the ranch entity. But all control of the ranch entity is in the voting trust, which can be managed more easily, and give Beth her 2 votes in that to make sure it goes forward in perpetuity, guided by the wisdom of John Dutton and his philosophies. We have the Yellowstone Ranch Operating Trust, which will periodically receive distributions from life insurance policies as the estates of the various Duttons mature. And that is the conclusion. So we've managed to put together a plan that will control and protect the Dutton Ranch in perpetuity. We've got funding mechanisms to provide it with liquidity, and we've established family control and hopefully a mechanism to deal with family disagreements. Thank you for listening to this presentation. We put together the Dutton family plan using tools that we often use for all of our clients in helping to assist them with their estate planning and business succession planning goals. One of the most important elements is family communication, family control, and protecting assets from unintended creditors. I'd be very pleased to talk with anybody who has an interest in learning more about how these tools can be utilized for your estate plan or business succession plan. As you might expect, we do not charge a fee for the first meeting and would, generally speaking, meet with you as necessary so we can develop an idea of what your goals and expectations are. And once we understand where you want to take your business or family plan, we then provide you with a firm estimate of what we would expect the cost to be. If you have any questions, please feel free to contact us. We'd be happy to meet with you and talk about your plans in more details.